So for this morning's talk, we have a wonderful presenter here with us. We have Liz McGrath, who is the Executive Director for Pegasus Legal Services for Children, and she's going to talk to us this morning about consent and confidentiality for children in New Mexico. So welcome, Liz.
Thank you so much for the opportunity to be here. As I said before we started, this is my first time doing an actual webinar, so forgive me if I flub occasionally. But I'm really excited to present this information to you because a lot has changed in the last 20 years or so from the way things were for children in terms of their consent and confidentiality in healthcare. And we've been trying to get this information out to people all over the state. We hear from kids that people don't have this information, and so they're being denied care or their confidentiality isn't being respected. So I'm really, really happy to see that we have people from so many different parts of the state. Just quickly to tell you a little bit about Pegasus, we are a nonprofit legal services agency located in Albuquerque that serves the civil legal needs of children and youth. So we're working obviously with a lot of kids who come from tough backgrounds, have been exposed to a lot of abuse and neglect and trauma, dislocated from their families, and also many times kids with disabilities. Our main areas of practice are kinship guardianship. We represent young parents in family law matters. We work with homeless and runaway youth, and we do also represent children in abuse and neglect cases. We do a lot of direct representation, a lot of community legal education, and we also do a lot of policy work. So please feel free to interrupt with questions as we go along, and forgive me if I get confused by the delay issue, but we'll figure it out. Okay, so, oh, look at that, it does that. Okay, so we're going to be talking about healthcare generally, reproductive health care, and mental health care. And we'll have a case scenario at the end to sort of illustrate what we're talking about. So generally speaking, I think everybody is aware that the default rule is that parents consent to all care for minors, particularly in the area of healthcare generally. The exception to that rule is a law that was passed in New Mexico in 2009 that applies to youth age 14 and over who are homeless or who are parents. So under the Uniform Healthcare Decisions Act, there's a section called Consent to Healthcare for certain minors 14 years of age or older. And basically an unemancipated minor 14 years of age or older who has the capacity to consent may give consent for medically necessary healthcare if they are, 1, living apart from their parents, or 2, the parent of a child. So basically they have to be 14, they have to be living apart from their parents, and they have to be the parent of a child. Okay, so let's see here. Okay. A healthcare provider or a healthcare institution is not liable for reasonably relying on statements made by an unemancipated minor that the minor is eligible to give consent pursuant to this section. So I often get asked, you know, how do we know that they're telling the truth? Well, I mean, generally speaking, I think that if a kid is coming to you and they want health care, they're not asking for crack cocaine, they're not asking, you know, to be able to live with their boyfriend or something, they just want health care, you can rely on their statement and you will not be held accountable. You know, you cannot be held liable for that. Another important thing to know about this, let me see if I do that, yeah. About this section is that parents or legal guardians of an unemancipated minor who receives medically necessary health care is not liable for payment for those services unless they consented to the medically necessary health care. This can create a problem if there's a copay and the child is unable to pay for that copay. Although there may be a way to waive the copay, especially if they're under Medicaid or something like that. Okay, so moving on to reproductive health care, and the three general areas are treatment and testing for sexually transmitted diseases, pregnancy-related services, and contraception. In New Mexico, there is no effective law that bars people of any age from consenting to reproductive health care. So it doesn't matter what age they are. If they're 6 years old and they want contraception, they can get contraception. Treatment is confidential for all reproductive health care, except parents may be able to access results of testing for sexually transmitted diseases upon request. So there's no affirmative duty for the provider to pick up the phone and call. And it actually says that a parent may get the information. So, I mean, there may even be some flexibility if they call and say they want the information. But that's what the statute says. Okay. Mental health services. The breaking point here is at the age of 14. Kids under age 14 have different rights than kids over 14 and over. So kids under 14, the general rule is that parents have to consent to all mental health treatment, except that a child under 14 years of age may consent to an initial assessment for medically necessary early intervention service limited to verbal therapy. And that therapy, let's see. Oh, no, let me go back. That therapy can last over a period of 2 weeks to do that, that initial assessment. And what that does is, for providers, is it opens the door for the provider to find out what is going on with that child. And often, under these circumstances, what you're trying to do is figure out what's going on at home and why the child is obviously presenting very much with needing some sort of assessment, and yet the parent isn't there consenting. And then once you get that information, the provider may then need to make a report to CYFD if for no other reason that the parent is not addressing the needs of the child. So it's very limited, but it does give a provider, like I said, opens the door a little bit to be able to help that child. Children 14 and over have pretty extensive rights under the Children's Developmental Disabilities and Mental Health Code. A child of 14 years of age or older has the right to consent to his or her mental health treatment. And that includes all sorts of outpatient treatment. It doesn't include any sort of treatment that involves aversive stimuli. So, restraints or some sort of medication used as a restraint, or, those sorts of things, electroshock therapy or something like that. They can also consent to psychotropic medications, but the parent has to get notice. So this is different than the STD testing, right? Where the parent may get notice if they affirmatively call and request it. Here, the healthcare provider has to affirmatively provide notice to the parent. The parent cannot veto the child's decision, but they do get notice. If a child 14 and over lacks capacity, there is a process for a parent to act as a surrogate without a court order. And the determination of capacity happens when 2 doctors decide that the child lacks capacity. Okay. So here's just a list of the various types of mental health treatment that minors can consent to. Anything that doesn't include aversive interventions. Okay, so confidentiality is the right to control access to health care and mental health care information. So it puts the requirement on the healthcare provider not to release information about the patient except as allowed by law. And the laws affecting minors' rights to confidentiality include HIPAA, state laws, and FERPA. It's the Family Education, I've got it written down here. Remember what FERPA stands for. What?
Isn't it Right to Privacy Act?
Family Education Right to Privacy Act, yeah. So under HIPAA, generally a parent has access to their child's medical records. The exceptions are if the minor consents to the care and consent of the parent is not required under state law. So you can think back to what I've just gone over. There are quite a few exceptions to that rule. Or the minor obtains care at the direction of a court, or the parent agrees to a confidential relationship. FERPA, the Family Educational Rights and Privacy Act. FERPA gives parents rights to access student records, and there is no state law exception. So you have to determine in the school-based health center setting whether the school-based health center is separate from the school, and it will be considered separate if it is clear that the healthcare provider owns the medical practice and controls the medical records. In other words, the site of service is not controlling. And I know this was a big deal a few years ago, so I think probably most people are familiar with this issue. Under reproductive health care, we talked about this before. It sort of goes back to the same analysis as HIPAA in that first provision. It says if the child consents, then they have a right to confidentiality. The law is silent as to confidentiality, but our analysis, and I think typically providers interpret this as giving the minor a right to confidentiality. If the parent's consenting, then they generally have the right to the information. If it's the child consenting, then they have the right to confidentiality. Okay, and again, test results for sexually transmitted diseases. All right. Consent to health care for certain minors 14 years of age or older. Again, the statute is silent, and the provider has to use his or her judgment, but we go back to that issue. If the child is consenting, then logically they would have the right to confidentiality. Okay. A child under 14, the child's legal custodian is authorized to consent to disclosure on behalf of the child. 14 plus, the child has the right to consent to disclosure of mental health records, except for the psychotropic medications. And I know that in the abuse and neglect setting, where psychologists are doing psychological evaluations or assessments on kids, it is routine that the results will be sent directly to a social worker and often then distributed to all the lawyers in the case and other people, and the child never has even any opportunity, or the child's lawyer never has an opportunity to even say, you know, whether the child wants to keep those records confidential. So it's something that we're fighting an uphill battle with in the abuse neglect arena. Okay, sexual activities of minors. So we're going to talk about the age of consent, statutory rape, and reporting. This, I find, is a very confusing area, and I've done my best to learn it myself, because I find that if I'm not actually looking at the law directly, I lose track of what's what. Everybody's nodding. Hopefully that means you can find it confusing too. Okay, So the age of consent is 13. A child under the age of 13 cannot consent to sex. Therefore, by definition, any sexual contact of a child under 13 is not consensual. Criminal sexual penetration of a child 13 to 16 years of age, it is criminal sexual penetration if the perpetrator is at least 18 years of age and is at least 4 years older than the child. So that's your classic statutory rape, right? 13 to 16, not 17. And the perpetrator has to be at least 18 and at least 14 years older than the child. Now, there are other forms of statutory rape. And one example is the child is 13 to 18. The perpetrator is a licensed school employee, unlicensed school employee, contract employee. All of those are school-related folks, at least 18 years of age and at least 14 years older, not the spouse, and they know or learn that the child is a student. Really, basically, the only difference here is that it includes 17-year-olds, right? So, if you go back to the classic here, this is statutory rape, and it's statutory rape whether or not there's a school employee. But here, if you're 17 and it's a school employee, then it would be statutory rape. Okay, criminal sexual contact, the same thing. It extends that to the 17-year-olds. Okay, reporting. And I'm breaking out mandatory reporting of child abuse or neglect and reporting of a crime, because I think those two things are often conflated and they're not the same thing. The duty to report abuse and neglect, and the person or people who wrote the statute did not get an award for clarity. And even the Court of Appeals was recently confused when the Court of Appeals held that every person did not actually mean every person, but in fact only the people listed in this list were required to report. That was appealed to the Supreme Court, and the Supreme Court said, no, actually every person means every person. And there are different theories about why it was written this way. I've heard that people say that because these are folks that would perhaps allege that they had a privilege. But I don't really see that, because a law enforcement officer wouldn't allege that they had a privilege. So, these are folks that I guess they wanted to emphasize specifically that they had a duty, but every person in New Mexico we are all mandatory reporters.
It's interesting because there's no male provider or psychologist on that list.
Unless the ... goes on.
Yeah, that's true.
Yeah.
But I guess if it's every person, then, you're through your list there.
Yeah, it is interesting because the therapists do have a privilege.
So many times that comes up in our work.
But it's possible that I didn't write out the whole list, but it is everybody. And then so you have to gauge whether you have a reasonable suspicion that a child is an abused or neglected child. And in our offices, you can imagine, although we recently have come up with an analysis that allows us to at least not report things that are in the past. But we are getting kids call us because they're being abused or neglected, or have been abused or neglected. So we have to figure out whether, with that information, do we have a reasonable suspicion? And often it's like, well, we don't really know. This is just a kid telling us. We have no firsthand idea that this has really happened. So we have to make those judgment calls, especially given that if kids knew that we were always going to turn around and blab what they told us, nobody would call us. But that's one step of analysis. And then the other thing is about reporting immediately. I think some schools have had a policy where teachers or social workers were required to run it by the principal first. And that is not how it should be done, right? Because it's not the school that has a duty to report, it's the individual. And so that individual needs to make that determination, and there should not be any undue delay in making the report. You know, let's say the principal's on vacation or whatever, and you're just going to talk about it next week. You need to do it in a timely way.
So I have a question for you about kids. So this is Kirsten Bennett. We didn't introduce ourselves here. I'm one of the your providers here at this table. It came up last year in my daughter's school that a kid disclosed to my daughter's group of friends that this was going on at home. So it was kind of an interesting discussion in the car going home. And I said, well, now that he's told you and he's afraid, you know, what are you guys going to do? And so the parents were made aware, and all of us encouraged the kids to go talk to the social worker at school. But it was one of these things that was a Friday afternoon, you know, when they found out. So who do you talk to at that point? So all the parents knew. The kids spent the night at one of the other kids' house, you know, so there was a safe place, and they encouraged this child to tell the social worker themselves in the, you know, on Monday morning when they got to school. But I just wondered how you would respond to that, because, you know, we try not to have our hair stand on end when our teenagers tell us things. But this idea of somebody told you that this is happening at home, and this little group of friends was sufficiently alarmed about what this child was sharing with them that they felt like they needed to tell the parents. So here we are encouraging the kids to go, but maybe we shouldn't have done that, given this list.
Right. Right. It may be that the parents should have, you know, talked to the child and encouraged and told, you know, I in my work, you know, I always try to tell kids, I'm not going to report anything until I've had a chance to talk to you about it first. Because again, you know, we want kids to feel safe coming to talk to us. But, you know, a lot of times they don't want to report it for a lot of different reasons. But you still need to report it. I mean, if you have a reasonable suspicion. So I would say that the parents would have had to decide, do I have a reasonable suspicion, and then go ahead and report it after talking to the child.
Yeah, it was interesting. The child trusted the friends, but not the parents. He didn't want to tell the parents. So the kids, you know, the kids were saying, can so-and-so stay at our house because? And we're like, well, okay.
Yeah.
So interesting.
Yeah. Yeah.
Another wrinkle in the...
Right, absolutely. It's not easy. It's not an easy thing to figure out, unfortunately. Okay, so the definition, and this is a key part. Definition of an abused or neglected child under the Children's Code refers to a child who has been abused or neglected by a parent, guardian, or custodian. So again, a lot of times people think that the duty to report applies to any sort of abuse or neglect. And it's not any sort of abuse or neglect. It is abuse or neglect by a parent, guardian, or custodian. So an initial question when considering whether or not you have to report is, specifically with sexual activity, is does the sexual activity of the child and the surrounding circumstances create a reasonable suspicion of abuse or neglect on the part of a parent, guardian, or custodian? Now, obviously, if this is something that you feel you should report, whether or not it's by a parent or guardian or custodian, you know, go ahead and report it, you know. But if there's some reason that you're struggling with whether or not you have to report it for instance, if you have a child who is in fear, or it may be that the abuse or neglect is sort of de minimis, or it's, you know, emotional abuse, and you know that this child with CYFD is never going to do anything in a million years, and the likely result is that, you know, the child may end up being more abused at home because they made the report than otherwise. So those things are always difficult, and that's where you're struggling with this, is, and especially with sexual activity, where, let's say it's a 14-year-old or even a 13-year-old who's having sex, you may think, or let's say it's a 12-year-old, right? And so by law, it can't be consensual. On the other hand, it may be in fact consensual, and the circumstances may be such that it has nothing to do with abuse or neglect by a parent.
What about an older sibling?
Well, you know, here's the thing. As I said, it's a question of the analysis that you have to go through, right? So potentially abuse or let's say a sexual activity by an older sibling may not implicate the parents, but you could still go through that analysis and say, I still need to report this. You know what I mean? It's just not automatic. You don't jump straight from sexual activity to reporting. You go through that analysis to be sure that you're really doing the right thing for the child. Yeah, I mean, you want to protect children if you possibly can. We all do.
Mm-hmm.
But there are times where that may not be the best thing for the child, and going through this analysis can protect children as well.
So if it is a person of authority abusing the child, like a school person, that would come under reporting a crime, not
Yes.
Okay.
That's right. That would be reporting a crime. And surprisingly to many folks, there is no duty to report a crime. We don't have a Good Samaritan law. In some states, they have a Good Samaritan law that places a duty on people to report crimes. We don't have that in New Mexico, so there's no duty to report a crime. In some places, there's a duty to report domestic violence, sort of like mandatory, you know, the abuse neglect statute. We don't have that here. Okay, so we talked about the person with the information has a duty to report, and the reporting should not be delayed by a policy that requires consultation with a manager, sorry. And as I said, no duty to report a crime other than abuse or neglect of a child by a parent, guardian, or custodian. Doesn't mean you shouldn't report it. It's just that it's not mandatory that you report it. So you can use some discretion. Child may not want it reported. Okay. Where does that leave you when a child needs help but does not want you to report? You know, you counsel them, you talk to them, you encourage them, you try to help them think about how they can stay safe. Talk to them about holding others accountable when they do harm, help them develop a safety plan, counsel child about the importance of getting help from supportive adults. Again, in all these situations where kids can consent on their own, let's say with reproductive health or whatever, that doesn't mean that children don't need help from their parents or other supportive adults. And as someone that's trying to help these kids, I think that it's incumbent upon us to try to counsel them about that. But it just doesn't mean that you do it automatically without being thoughtful about it. Okay, so here is a little fact pattern. Christy is 15 years old and she ran away from home 3 months ago. She's been living with a friend's family. Christy has some health problems, but is being told she cannot access treatment without authorization from her parent or legal guardian. So Christy has a sinus infection. Does Christy need her parent or legal guardian to authorize treatment?
No,
Why not?
because she's older. I mean, she's at the age where she's a runaway or homeless and can access it for herself.
That's right. And if she can consent on her own, will the treatment be confidential?
I think so,
She
because
pays for it.
what did you say?
As long as she pays for it.
But is it confidential because it's not behavioral health? Is it confidential just because of her age?
It's confidential because she is able to consent on her own for the treatment. Okay, what if Christy is 12? Can she consent to treatment?
Yeah, because she's homeless, right?
Nope, she has to be
Yeah.
14 or older.
Oh.
So yeah, and for others out there, what's the answer that comes up for you guys? What if Christy is 12? Can she consent to treatment? And you can write in your chat box as well.
Give her plenty of time. I can't see what's being said up there.
No, she is under 14.
That's right.
That's right.
She's under 14.
She's under 14.
And will the treatment be confidential? Well, she can't consent, so she's not getting treatment, but it wouldn't be confidential in any case because parents have access to all the records for kids under 14.
So
what would you do?
yeah, so what would you do? The question.
If she's
If a 12-year-old runaway comes to you, oh, good question. Let me wrap my mind around that one for a second. I think then you're getting into the question of what's going on at home. Why is this 12-year-old run away?
Mhm.
Now, okay, here's an important thing. Usually when 12-year-olds run away, they're not like wandering the streets, right? They're with their auntie or their, somebody they're living with.
Mhm.
There's something called a caregiver's authorization affidavit. I should include that in this presentation, shouldn't I? Why haven't I? Sorry about that.
Okay.
There's something called a caregiver's authorization affidavit. So let's say that my, at this point, my granddaughter's friend, right, runs away to my house. I can't say my daughter anymore. And she's staying with me. She's living with me, and I need to get her some health care. I can fill out this form saying that for health care that's not school related, I have to be able to put down that I've either contacted the parent and they don't object, or I've been unable to contact the parent to get the child the health care that they need. And then that form gets notarized, and I will get you guys this form, and there are instructions.
Okay.
This is a statutory form. It was created when we passed the Kinship Guardianship Act. And it allows the caregiver to help the child enroll in school, get school-related health care, and then any other health care as well.
Okay. For those of you out there, is anyone familiar with that affidavit, or does your clinic have access to those forms? And one of the things that comes up for me as a provider is not having access, even when you know what form you should be using. Where do we get that? And what's coming up for me is, is there an app for that? Like, I feel like there's no real great place for us as providers to really be able to access this very important information when we need it.
Well, and the other thing is whether you want the providers to be providing the form, or whether you want to be able to tell the caregiver, call this number, or go, so they access it on their own, so you're not giving legal advice or something. And We actually don't have these forms on our website, but I've been wanting to do that, and we will do that soon. They are also available, I believe, on the Supreme Court website. But I can also get you that information about how to access. That's wonderful. Yeah.
Liz, Bessie has a question. She says, is the state responsible to give service, public health, and then referral to family services?
Okay, so is the state responsible? I don't know quite how to answer that question. I mean, if it's a healthcare provider, then they're going to provide healthcare if they can. It's the same analysis, right? I mean, it applies the same. Am I missing something about that question?
Yeah, I wonder if the tricky thing is how sick is the kid, right? I mean, you know, sinus infection is not the same thing as getting in a bicycle accident and being 12 and ended up in the ER, and or some, you know, or your parents, you're a 12-year-old riding your bike and you don't have a cell phone, you get hit by a car, if someone calls the ambulance, you show up in the ER, they don't know who you are. I mean, obviously you're going to give care at that point, regardless.
It's an emergency.
It's an emergency. You know, sinus infections don't tend to be an emergency, but somebody could present as very ill.
Yes.
I mean, if they have gone without care for a long enough period of time, sinus infection can make you look really bad, right?
Right.
The physicians and the
one of the cases that caused us to get that consent to health care for certain minors passed was a young woman that came to us. She was 16 and she had one kidney. She had been living on her own for a long time. She had a really sad background. One kidney, and she had chronic kidney infections. And in that case, the doctors were treating her because they saw that as emergent. But, you know, another doctor might not have. So it was really obvious that, you know, she needed to be able to access healthcare on her own. We sort of regret, I mean, I would prefer to take off the age 14, but that seemed like a reasonable compromise.
So is that an answer to this question? And that the state, in other words, being entities that provide service to all people who show up, you know, do you have that because you're a provider, and whether someone can pay or not? I mean, ultimately, I guess it's the state that pays, right?
Right.
Good question, Betsy. Thanks for that. Yeah, exactly. Yeah.
Okay. So Christy has a urinary tract infection. She's 15 again now. Can she consent to treatment for a urinary tract infection?
Just a regular 15-year-old.
Yeah. Well, she's run away. We're going back to the original thing.
So the runaway, she's 15-year-old. For those out there, Christy has a urinary tract infection. Can Christy consent to treatment?
Yes, I see. Right.
Yes,
right.
because she's over the age of 14. Yes, she can.
Right, because she's run away and she's over the age of 14. What if she's 15, and as Jane said, she's at home. She hasn't run away. Can she consent to treatment of a urinary tract infection?
I want to say yes. But
why?
For those out there.
No.
No.
Well, I think that I put this one in because I thought maybe there was some way you could say that it was reproductive health care.
Right. That's what I was going to say.
So wasn't that
the
far
sexual
off.
activity can, you know, cause you to.
It's in that same general area.
I wouldn't do it. I mean,
yeah.
So you have,
Betsy said, hopefully it's not chlamydia, so she won.
Okay, so she's 15. She's got a urinary tract infection. She ran away from home. Will it be? She can consent to treatment because it's health care. She's over 14 or over, and she's not living with her parent or legal guardian. And will the treatment be confidential?
Sorry.
So she's still a runaway. She's 15.
Oh, gotcha.
Um,
And she consents, it's confidential.
if she consents, it's confidential.
Confidential.
Right. Okay.
Yes.
Christy also says she's been very depressed and would like to get counseling. Can Christy consent to mental health counseling?
Yes. 2 weeks. 2 weeks.
She's 15.
Oh, she's 15, she can.
She can. Right. And she could do that even if she were living at home.
Yes.
Did that make sense to everyone out there? That Christy being 15 and living at home?
Either way.
Either way,
Either
living
way.
at home or runaway. Can Christy consent to treatment? And the answer was yes. And will that treatment be confidential? Yes as well.
Yes, because she's 14 or over.
14 or over.
It's confidential. Now, what if Christy were 13?
Then it would be the 2-week window.
Then it would be the 2 weeks for an initial assessment.
I should have jumped in there. That. For those of you out there, if Christy were 13, you didn't know you were going to be pop quiz this morning. And I think these are excellent examples because it shows just by tweaking things just a little bit contextually, it can really change. So great question. So Gustavo asked, what is the 2 weeks?
What is the 2 weeks? Is that a question?
Right. And then Lisa came up with, she can get an assessment and then 2 weeks of treatment.
Right.
And then 7 sessions confidential. Oh, what is 2 weeks? I'm sorry, Gustavo. Okay, gotcha.
So the 2 weeks is the initial assessment can take place over the course of 2 weeks.
And
Right.
I think that's important because Lisa, I think it's important how you worded it as well. It's an assessment only and not 2 weeks of treatment. So
Exactly.
you can see a child for treatment related. Those 2 weeks just allows you 2 weeks to actually get assessment information and come up with a treatment plan.
Right. Although I imagine that a provider would try to stick as much treatment in there as possible in the context of the assessment, to try to provide that child with some support during that time period.
So Jeannie, what's the question about where here, I don't know where Bonnie is,
Yeah.
is where is here and where is 7 sessions confidential? Is that would be true if the child was 14 and older, but is that true if the child's 13 or under the age of 14?
I am not familiar with that. What does that relate to?
Yeah, I don't know.
Well, it looks like Bessie Lopez is saying that their policy is 7 sessions.
She's in Puerto Rico, I think.
She is.
Oh, she's in Puerto Rico.
Yes.
Yeah.
Puerto
Wow.
Rico.
Cool.
Interesting.
And is that for kids of any age, or is that just for under a certain age?
Any age.
Any
Wow.
age.
Wow.
So in Puerto Rico, older kids don't have the right to consent on their own. Is that correct?
Long term, it sounds like.
They can consent for mental health.
They can consent. For more than 7 sessions? Oh, this is the delay. Okay.
Only 7.
Only 7. Okay. Yeah.
Huh.
So all of this stuff is state by state.
Yeah.
And New Mexico is really pretty advanced in this area. We have pretty good laws compared to other states. Yeah.
Thank you for that, Betsy. Thanks for sharing.
Mm-hmm.
Okay, so let's keep going here. All right. Christy says she is 4 months pregnant and having abdominal pain. Can Christy consent to treatment? And again, this one is whether or not she's a runaway.
And how old is Christy? Christy right here.
She's 15.
Everybody's saying yes.
So
Yes, everybody's
saying
saying yes. Okay, great. Sorry, I couldn't see that. Okay, and will the treatment be confidential? Yes.
Nice job, everyone.
And we already answered whether that applies whether or not she's living with her parents, because she has the right to consent to come to reproductive health care, and that is regardless of age. All right, now Christy tells you her 19-year-old boyfriend is the father. Is it statutory rape? Christy's 15 and her boyfriend is 19.
So that's over 18 and the 4 years older.
This is where I start asking birth dates.
Right?
Literally, I had that.
makes
I had
sense.
that recently where I calculated the birth dates and I was like, nope, it's not statutory rape.
Yeah.
It's like 2 months difference.
Okay.
So it's 4 or more years older?
4 or more years older. Okay, what if Christy is 13 and her boyfriend is 17?
It's creepy, but not statutory rape.
Creepy happens all the time.
Doesn't it?
Yeah, but not statutory rape because her boyfriend could be 4 years older, but is
Under 18.
under 18. Right. What else say? So let's say Christy's 13 and the boyfriend is 18. Then yes, right? And what if Christy is 18 and her boyfriend is 25 and a school employee at the school that she attends?
Yes.
Yes.
That's really creepy.
Yeah.
That happens all the time too.
Yeah, I know.
Did that make sense to everyone? Any questions on that? These are good. These are
Mhm.
good.
Yeah. And I have made myself a cheat sheet on this, and it's not really suitable to hand out, but I can fix it up and make it more suitable to hand out. It's just a real summary.
Yeah.
Yeah, so I can do that.
That would
So-
be great.
I know. That's what you need, isn't it?
You really do.
Age of consent app
What's your
by
birthday?
Pegasus.
What's your
How do you
birthday?
figure all this stuff out?
Yeah, good idea.
So I have a question
We'd
about
make millions.
Yeah,
For
there
each
we go.
state. If you did it for each state.
Can you imagine? And how healthcare providers would love that?
Yeah. Algorithm for every state.
So
Right.
here's a question. Oh, I'm sorry, Kirsten, go ahead, and then we have a question on the chat box.
It may be the same question, but the last one, if the person's not a school employee, then that's nothing, right?
That's nothing. That's right. Because she's not a minor.
Right.
Because she's not a minor.
Oh, you know what? That's wrong, actually. I think that's wrong. If she has to be 17, not 18, for it to be statutory rape. Right.
You said 13 to 18.
I know, but I think it's
less than
2
18?
18. It should be
2
13 to
18.
17.
Okay.
Okay.
So
think
Gustavo
that's
has a
right.
question.
Because 18, you're not a minor.
You're consent,
So,
right.
So it's a little different.
I think it's actually the statute is written that way, 13 to 18. But 18 is you're not a minor, so it can't be statutory rape.
18.
Yeah.
Okay.
I think that's why I have it there, because that's the way the statute's written, but it can't be.
Okay.
Gustavo asked, what is the law for something that happened 10 years ago and the patient is opening up today?
Okay, well, this goes back to the question of, first of all, I do not know whether there was a statute of limitations that has expired, so maybe this person couldn't be prosecuted
What if it's
anyway.
3 years ago?
And I'm just saying I don't know what the statute of
Yeah.
limitations is, so it could be 3, it could be whatever. In terms of reporting, again, first question is, does it implicate abuse or neglect by a parent or legal guardian, right? So let's say that a child somebody tells you that she was 15 and she had consensual sex with a 30-year-old, and she and that's it, right? At this point, how are you going to make an analysis of whether or not there was abuse or neglect by a parent involved, right? And even if she says there was, my parents were never around, they didn't supervise me, blah, 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 you don't really know happened a long time ago. Then you have to say, what do I really have a reasonable suspicion? And frankly, what's anybody going to do about it now?
So Liz, we only have a couple more minutes,
Yes.
but Jackie wanted to clarify, just to be clear, the 18-year-old student and a school employee is not statutory rape because she is of legal age.
That's right.
That is correct.
Yeah.
Okay.
Yeah.
Okay.
But it's interesting that the statute is written that way, because it definitely does say 13 to 18. But the question is, it's up to 18, not including 18. But in the 13 to 16, one assumes that 16 is included.
Is included.
I'm going to have to go talk to some of my lawyer friends about that.
It can be, yeah, it
Tricky.
can be confusing.
They make it even trickier than
Right.
it already is.
Right, and she's, would it be a school policy to just not date students regardless of age? Good policy, Jackie.
I'm guessing that is the school policy.
Yeah. So it might be a crime.
Yeah.
Well, it certainly is at the university level, and most of those
Absolutely.
students are over the age of 18 or at least 18. So
Right.
that's a university policy, in the news, the last few months.
And EJ would like us to repeat, or Liz for you to repeat, if the pregnant child is 15 and baby's father is 18, is it statutory rape?
Well, okay. Depending on
Good question.
when she got pregnant, right? Because she may be 15 now, but she got pregnant when she was 14. Because 15 to 18 wouldn't necessarily be 4 years. But if she got pregnant when she was 14, then it probably would be 4 years. So you date it from when the intercourse happened.
Gotcha.
To figure out whether it's 4 years or more.
Needs to be an algorithm. So I know that we're getting close, we're ending the hour, it's 9 o'clock, but does anybody have any questions? I don't want to cut anybody off who may have another question for Liz. This is wonderful information, and there's a lot of it though, and it just shows you how a little change of context can really change the outcome in our job in terms of reporting and what to look for and forms. And so just make sure no one has any other questions. Liz, what would you recommend, for example, when we are faced, something like this comes up, we have someone in front of us in the office and the deer in the headlights kind of come on, like, okay, what do we do? What would be your advice, like as a first step? Getting on Pegasus website, the Supreme Court website, I mean, what would you do as a first step, knowing that this is a complicated
Yeah,
process?
It's complicated, and oftentimes people will call us, and probably, somebody here has probably called us before. Jane, we probably consulted on something before. We can't advise you. We can't give you legal advice, right? Because you have your own counsel somewhere where, they may be up in Santa Fe or wherever. And oftentimes for providers, there is a lawyer involved at some level. And in my experience, those lawyers do know what the law is, and they can advise you. If you call me, I can tell you, well, this is how we see it. I'm not advising you what you should do, but this is our analysis of how it works. But I don't think that this information is, I can't think of a reliable online source.
Okay.
There probably are. There's probably a lot of information out there. I don't know how reliable it is.
And Jeannie, just sort of an odd side thing, I gave a spiel for Envision last year at a nurse practitioner conference at UNM, so the person who was in charge of all the nurse practitioners. And I got ahead of my time and listened to the lawyer who was there. UNM has legal counsel, and they're on call 24/7. So you can pick up the phone and they can answer those kind of questions. I didn't even realize that that was possible.
Yeah.
And this gal was, oh yeah, we take call just like everybody else. And if you can't remember, you can always call the PALS line, because the PALS line operators will put you in touch with the person who's on call for whatever service that you
Oh,
need.
that's
So
great.
that's
Great.
nice for the
Great
UNM
info.
providers.
Right.
I don't know how it works for, you know, if you're in
Cal
Mora
is
or another
statewide, isn't
or another school. Yeah, that's true. But the legal advice would be only if you're a UNM provider, then that's your UNM counsel. But I you know, this question of if you're in Mora and you know you have a student come into your school-based health center, clearly we have HIPAA and FERPA going on there. The difference, because it's an outside entity, but who would that provider say call if they don't know who that is in their own school system? Is it state PED? Is it, you know,
Or
DOH? Yeah.
Yeah.
Right.
Probably.
So anyway,
And maybe,
more complicated.
absolutely, maybe just a reminder to us, especially those that work in rural areas, to use this opportunity as a reminder to maybe refresh ourselves about who do we call in our community if something like this were to come up.
So I just want to add that nationally, if there's other people in other states besides Bessie Lopez, that the Center for Adolescent Health and the Law, it's cahl.org, has information on confidentiality and consent for all 50 states and maybe some territories as well.
Great, thanks for sharing. So just one last question and we'll wrap up for this morning. This is from Sandra. So she just wants to clarify. So age of consent means that prior to age 13, we do not consider any sexual act consented to.
Correct.
Correct. Second, am I right to interpret that in statutory rape, consent is irrelevant?
Correct.
Correct.
That's usually
Good
what
question.
makes it statutory rape, is that there was no actual coercion or
Coercion involved.
yeah.
Excellent questions, and everyone did really well this morning with the loops that were thrown to us from Liz. But I really appreciate Liz. This was some great information.